Good afternoon. My name is Ala McCoy. I'm Director of Startup Support at the University of Maryland's UM Ventures. And I would like to extend a very warm welcome to everybody who joined us today for the next installment in Startup Fundamentals Workshop Series, both live audience and those watching it on our Startup PMD YouTube channel. This workshop series is offered by UM Ventures and Maryland Technology Enterprise Institute at the University of Maryland, College Park. So everybody who is here attending the live session, please feel free to submit questions. You can use the Q&A function at the bottom of your screen. And our presenter today, I would like to invite you to ask those questions as the webinar is going on, and he will stop the presentation to answer your questions. So please keep them coming. So as a reminder, we are recording it and it will be posted on YouTube. So if you would like to remain anonymous, you can do so by selecting the Submit My Question Anonymous option. So today we will focus on recent developments in ever-evolving patent prosecution and post-issuance considerations. As you know, patent landscape continues to evolve very quickly. And for startup founders, researchers, tech transfer professionals, staying current is really important. So today's session is designed to make those changes more practical and accessible. I'm very pleased to welcome today's presenter, Stephen Shipe, partner at Barnes & Thornburg. Stephen is a former patent examiner and former law clerk to a lead administrative judge, and he brings deep experience in patent prosecution, post-grant proceedings before the Patent Trial and Appeal Board, IP counseling, commercial strategy, and portfolio management. His work spans clients from startups to multinational organizations, so he brings a very valuable perspective on both the legal and commercialization sides of patent strategy. So Stephen, the floor is yours. If you would like to take the microphone from here. Thank you so much for joining us and spending your time with us today. Floor is yours.
Ala, thank you so much. Thank you for the introduction. It's great to be with you. Thanks to UM Ventures for inviting me. I'm excited to talk today. We have some really interesting stuff that is really currently going on. We're seeing a lot of changes at USPTO, and as I put together this presentation. I pieced it together from a variety of other talks I've given in the past. But the new things that were going on have shown to be more impactful, I think, to patent prosecution than maybe your average year or 12 months worth of work, because we see updates from USPTO and they tend to amount to kind of reminders along the way and maybe less impactful to the practice. Whereas with new Director Squires at the helm, we're seeing tangible differences and new policies take shape that are worthy of attention and at least being aware of. So I'm hopeful to share some things that will be new for our seasoned practitioners as well, who might know the ropes of ordinary typical practice. And certainly they'll be interesting to those who haven't heard about these initiatives. So let me go ahead and get my slides up here. Let's see. Are we able to see that there, Ala?
Yes. We can see the slides within presenter mode. Now they are. Perfect.
Better. Okay.
Would
So
you
I entitled this. Go
let me
ahead.
know
I'm
when
sorry.
you would like me to launch the poll first.
Oh, great. Yes. I asked Ala to just put a poll out there to indicate level of experience, just so I can gear a little bit of the talk. Like I said, I think there's going to be some information for everybody, but if we have a ton of really expert practitioners, I can talk a little bit more in detail about things more relevant there. So if you would just respond there. And Ala, I assume you'll give me some results, or I'll see them as we go.
Yes, so right now, the distribution is 22% complete novice, 67% moderate knowledge, and 11% expert.
Great. A nice mix there. Thanks to everybody for responding there. So I entitled this Fuller Patent Process, and like I said, I pulled from some other presentations and then also some totally new information. But the idea was to review post-issuance, post-grant issues. I don't like to use the word post-grant because that can have specific connotations, but post-issuance, and then also some less common USPTO practice, both in the appeals side and subject matter eligibility specific things that I think we've seen some changes, some differences in how USPTO is going to look at those issues, and I think it's important to be aware of them as we move forward. So hopefully this will be informative, but the idea is to bring those concepts back to portfolio development and how we actually do the practice, knowing those later downstream items. I may have skipped. Okay, here we go. So just to give you a quick preview of who Barnes and Thornburg is, I'm a partner in our Washington, D.C. office in the intellectual property department, but we are a nationwide law firm, over 20 offices, and to the point where this slide is now out of date. Our newest office in Baltimore is not on this slide, and maybe a few other smaller ones that we've recently added. So a lot of growth there. One unique thing about the firm is our intellectual property department that has been a mainstay. Many of our peer firms in general practice don't maintain an intellectual property department the size and scope of what we have. That has been a foundational department for us. So it's kind of interesting from the general practice area these days. Um, Lots here about our core intellectual property counseling and other portfolio stuff. Lots of registered practitioners and the full gamut of patent practice experience, as well as trademarks and other intellectual property. Great shot of my slightly younger self here. But yes, I'm a former examiner, as Ala mentioned, and I clerked for a lead administrative judge in the time at PTAB that was at the advent of IPRs and the new revamp to the Patent Trial and Appeal Board. So a really exciting time to be part of that board and see kind of the inner workings that are going on there. Pardon me. So our agenda for today, tried to keep it short in terms of the agenda, but broad in terms of the scope of materials, because I think there's a lot to be taken away here. But we'll start with the life cycle, a reminder for our seasoned folks, and then a little bit of a vocabulary overview for our more novice folks. The life cycle at USPTO, and then what happens as the patents are granted and things to be considerate of. A review of the standard examination flow. What are we talking about as we go through prosecution and even developing the applications? And then we'll get to the reminder on the less common USPTO practice, and then overview of post-issuance considerations, where I think we'll find some interesting new tidbits here. So a quick refresher, different types of patents and patent applications, a design patent, provisional, and utility patents, the phases of patent applications from preparation to issuance. I'll mention appeals and some interesting things there. And then also we're considering enforcement and licensing as the downstream things for commercialization. But what I'm going to focus on today is some issues in the really related to the enforcement area, really how patents can be challenged after they are granted that we want to be aware of, and we want to adapt our prosecution to consider how those challenges take course and where we can strengthen the patent by knowing those later processes. Excuse me. Okay, so starting with types of patents, design patents focus on ornamentality, the visual aspects of design. We've seen some changes there in the law at the federal circuit level, but design patents are a significant form of patent protection. A provisional patent, rather a provisional application, that is really amounts to a timestamp. We're getting a timestamp from USPTO on the concepts that we write down. And then a utility patent application, I think we should be talking about. This is really what we think of when we just say generically a patent or a patent application. We're talking about a utility or a non-provisional patent application. There's also a foreign application, if you will. That's called a PCT application. Also, all these sorts of applications are considered a utility patent application. and that would be the common term to describe a generic patent application. I want to take a quick note for our new folks that a provisional application does not go through the examination process. You must file a utility application, which can be linked to an earlier provisional application in order to go through the examination process and ultimately result in a patent. I'll talk a little bit more about that briefly as we go on. There's also a fourth area called plant patents, which are specifically directed to new plant species. It's less common, although we've seen an uptick with certain industries. So I want to go forward to the actual practice and the phases of examination and prosecution. How do we actually get to an issued patent, right? Really three stages: preparation, prosecution, and then the allowance or issuance of the case. The preparation stage, that is where you're typically going to prepare the materials that actually form up the application. It's a very specific and intense process at times. Oftentimes, the majority of folks are going to use a legal professional to do that preparation, and they'll work in concert with the inventors because it ultimately is a legal document. Although it's describing a lot of technical information at times, depending on the how high level the science is that goes behind it. It is really a legal document, and that's the job of the legal professional to translate the technical into something legal and defensible and use good skill and judgment to protect the concepts underlying. So I mentioned a provisional application that could be used as a timestamp, and then conversion, or I don't love the word conversion, but linking that provisional application to a non-provisional. That's the utility case that actually goes through examination. And then, so once we have an actual utility case on file, we have prosecution. I want to take a moment here, again, mostly for vocabulary's sake, to review prosecution. Typically, we're going to go through phases of prosecution. And what I have illustrated here is really one phase of prosecution. During that phase, you're typically going to see the examiner issue two actions, two office actions is how we refer to them. It's typically a non-final office action, and then later on a final office action. At any point during the prosecution, of course, the examiner could be persuaded that there's allowable subject matter and issue the case. But until that time, they're going to have office actions. And those are the office's formal way to communicate what its positions are. And typically, the examiner is going to reject your patent application claims a number of times. And that's part of their job, is to develop the record, have you put comments on the record, and develop the case a bit before they allow it. That is part of the examiner's role and function at the office. So a first office action, it's abbreviated here, non-final office action, would be issued, usually rejecting many of the claims, if not all of them. And then the applicant has an opportunity for response. They file a formal written response opposing the rejections, amending the case, making changes in reflection on the examiner's positions. And then the examiner retakes up the case and would consider whether to issue a final office action or second office action. At that point, the applicant has the opportunity of responding again. And after final response is an option. It's a limited option, but it is one. And then to decide whether to file what's called an RCE, a request for continued examination. And ultimately, an RCE is going to restart the process and enter the second phase of prosecution. The difference in the important point here is that the RCE, at the request for continued examination, there is a government fee imposed, an additional fee. So as you restart prosecution, an additional fee is paid, and now you get the examiner's attention for more responses. This is an important discourse to understand, and the timing to understand. Typically, examiners these days are going to expect that at least one RCE is going to be filed. So that means you're going to incur at least one fee of the government cost after you file the application, which itself has a cost. The filing has a cost. But we're going to see typically one RCE, and that's part of the examiner's job. They're also slightly incentivized to have you file that RCE because the office gets paid by those fees. And so the examiner essentially gets paid according to fees accrued. The office has a incentive to accrue those fees. So there's a little bit of a balancing act there. As I mentioned, allowance and issuance can come at any time during the course of prosecution. Examiners can be persuaded for any variety of reasons. Um, so we're going to carry that knowledge forward. I wanted to give a little information here about a service that I know of. I have no affiliation with this group called Juristat. To my knowledge, it's still a free service. There's no subscription here, and I'm sure there's other services that are similar. But what we're seeing here is some information about a particular patent examiner. And I just chose this examiner at random, so the numbers don't matter at all. But essentially, when you get those office actions, you have an examiner that's assigned to the case. And what Juristat allows you to do is go in and look up the examiner and see these overall statistics here. We can see disposed applications on the top right. We can see allowance rate on the bottom left, and then average office actions per application on the bottom right. So in terms of disposed applications, top right, we can see a lot of the examiner's experience, how many quantity of applications they've handled, how senior are they, how long have they been at the office. You can see this examiner had a huge uptick in the number of applications disposed in the last 2 years or so. That's just interesting to know that their practice has ramped up. On the bottom left, the allowance rate, we see a comparison between the individual examiner and the average examiner within this particular examiner's art unit. So that's their technology area of other examiners. And you can see their allowance rate is much lower at 60% compared to 70% of the average across their art unit. So it gives you a little bit of information about the particular examiner and how difficult it might be to get arguments to them to agree to arguments and to move cases along. And then if we look at the bottom right, the average office actions, you see here the examiner has an average of about 3.1 going to 3.1 office actions per application. So about 3 office actions issue before an allowance comes. So if you remember back to our sequence of prosecution, if 2 office actions are typically issued in a phase, then that means this examiner typically sees 1 RCE, one reboot, go into the next phase, and issues at least 1 office action in that second phase. So that's pretty typical, but you see across the art unit, the particular art unit, the average was only 2.2. So that's only slightly more. That's more likely than not that cases are being allowed, and that varies considerably by the art unit. It can considerably by the technology area, of course, the particular examiner, the client itself, the applicant itself, who might want to be more aggressive or not be so aggressive. Those are all factors there, but we get some good statistics we can use in determining how to negotiate with that particular examiner. I'm going to move on to standard USPTO practice, and rather we're kind of recapping what I've just discussed, but adding the idea of continuation applications. Most, if all of our seasoned practitioners are going to understand continuation practice, but I think it's worthy of just mentioning for those that are newer to the practice. So the case is not that one application has to issue in one patent. It's not just one patent per case. You could have multiple patents that issue out of an individual application. So same specification, same drawings in the application, same subject matter could be disclosed, but we're pursuing multiple different patents that could have different scope. And that could be in the form of continuations or divisional applications. So both of those, continuation application and divisional application, are used for slightly different types of differences between their sister cases, but they all are called continuing applications. And one of the important things to know about this is that you can process these cases that are sister cases, but do it in a way that is serial. And the reason that's important is because as I go in as a practitioner and I pursue a first patent for my client, they can get a first patent issued, and then at the same time, they can now enter the continuation application. And what that does is the continuation application can begin later in time, and its course of prosecution can happen after issuance of the original patent. The benefit is you stretch out the lifetime of the application. So that last bullet, maintain the application alive. You can, as long as there is at least one application in the family staying alive, then you can continue to go back and file additional continuation applications and to harvest more intellectual property from your single individual application. That's important because we learn more information over the course of years. We learn what's more important commercially to the product, to the industry. Now we can go write more targeted claims. We can decide that different features are more important to us than we expected when we originally filed the case. We can't include new information, but we can reframe our approach to protecting the intellectual property associated with the commercial products that come out of it. And in general, you can grow the portfolio this way because you could have multiple patents that take different approaches, perspectives, scope, differences between them in terms of protecting individual technologies. So very important to strategic growth of a patent portfolio, whether it's a full spectrum of technologies or even just a specific technology area. Here's an anonymized diagram of a particular patent family or patent application family. If you see over on the left, is this particular case started with a provisional application in the blue, and then ultimately the yellow box was the original application that it granted. And then what we see is stemming from this yellow box, the linear stack of 4 cases, were different sorts of continuing applications. And if we look just to the top level of those continuing applications, you see there were multiple continuations that were filed just from that top level downstream. We would call it like a grandchild or a child application. And so you can see from left to right, that illustrates the timeline that the application was available for patenting. Had the applicant elected not to file a continuing application and just accepted an issued patent at some point and stopped the process, then the lifetime would stop. The patents continue on and can be maintained alive themselves, but there's no longer an opportunity. Once you interrupt the chain of continuity for the applications, then you no longer can go back and harvest additional intellectual property there. Okay, so now we've got some vocabulary, we've got some baseline information here, and we're ready to move on to a little bit more of the juicy practice tips and new things that are going on. So some of this is going to be a mixed bag of information, vocabulary information, but you're going to start to hear the new stuff coming out. So I want to mention appeals. I want to mention subject matter eligibility, two tougher areas. We're going to appeals when we can't get to agreement with the examiner. The examiner is remaining too hard-headed, steadfast. We can't agree. We see things differently. And ultimately, we don't see a process forward where we're going to get to agreement. So we may consider an appeal to the Patent Trial and Appeal Board, which is part of USPTO. It requires the case to be twice rejected. That just means some process has had to go on. One important tip, this is going to be a minor one for good practitioners or for seasoned practitioners, the pre-appeal conference request. I can't stress it enough. It's a really valuable tool. There's no government fee associated with it. Of course, there's costs of preparing the paperwork for it, but this is a great way to approach the concession of or the idea of appeal. What it is ultimately the examiner who you're working with has to go and work with 2 other generally senior examiners, usually the SPE, the supervisory examiner, and 1 other primary examiner. And they have to have a conference and discuss the case and the rejection and decide whether or not it should go on to appeal or whether the case should be reopened for prosecution and potentially allowed. It's a relatively limited program in that you only get about 5 pages in order to make your case. But it's a good tool to try to, show the examiner that you're serious about it, make them be accountable to other folks if they're seeming to be unreasonable. And it's also a good way, it's an economical way for the client. If it's something that's really important and the appeal is appropriate, if you can't get any more ground, it can be an economical tool because there is significant cost to go on to appeal and to write an appeal brief. And yet we don't want to just go, full bore into every appeal. So the pre-appeal conference gives you a chance to test out the arguments, to kind of focus more on the technical, maybe less of the legal arguments and more of like the trying to persuade the examiner one final time. And yet it's a staging ground to get your appeal brief produced. So you get the opportunity to talk directly to the examiner and try to persuade them, and yet you're doing some of the work that would benefit the appeal brief and maybe bring two bites at the apple for relatively the same cost because you're ultimately outlining the appeal brief that would come later on. So great to use if you haven't already done that. And then briefing and hearing comes out of the appeal. That's ultimately what comes if the pre-appeal conference request doesn't carry the day. Ultimately, an appeal brief, a reply from the examiner, response from the examiner, and then a reply from the applicant to address that response. I typically recommend to my clients and to applicants to use the hearings at appeal. I think getting in front of a panel to explain those points is a very valuable tool. It's additional and it's optional, but there's a lot of times where you cannot simply grasp where the panel, where the individual judge is having confusion or difficulty until you're live in front of them. You don't get discourse with the judge like that. So having a hearing and an opportunity for them to question and for you to respond to it can really be invaluable for important subject matter. If the technologies are very important to the commercial plan, this is definitely a process to know about and to use to your advantage. Um, Subject matter eligibility is a little bit different than appeals. This is not necessarily a patent USPTO practice, but it's a really important topic. It's a huge gray area, as most folks will know that have bumped into this. It's essentially an area of law that says that certain things, this was once applied vigorously to software patents in general. Now we have consensus that software patents are patentable, but the way that you approach them can implicate subject matter eligibility. So we're going to run into this legal area where we have to decide whether it's even eligible for a patent, meaning should it be categorically excluded? There's no arguments that can overcome or changes to the application that can overcome its eligibility. What we're ultimately after is to show that there's a technological improvement, a practical application here. So here's where I want the seasoned practitioner's attention. Declarations. We're probably familiar with 132 declarations, but the USPTO, Director Squires, has recently issued, just the end of last month, has issued a second memo highlighting the use of declarations, 132 declarations, to combat subject matter eligibility, those rejections. What we're seeing is that examiners are overusing Section 101. They're using it where it shouldn't be used. They're using it in ways that are really not the examination purview. If those challenges needed to be made, they would be made later down the line or by a judge that has appropriate understanding of that law. And yet that overuse is difficult to overcome because it is a requirement, a statutory requirement. So the examiner should be issuing some of these rejections. But ultimately, Director Squires has recognized this and has identified these 132 declarations, which can be given by, it doesn't just have to be an inventor, it could be an inventor, but anybody with knowledge enough to state and support technical information within the case. So the original memo was issued, I think, in December or late of 2025, but the new memo in April kind of underscored that the examiners need to consider all the evidence of record, including these 132 declarations that can help sway, push the needle a bit and overcome some otherwise difficult Section 101 issues. I'm using it very frequently. We're probably a half dozen in last month where we're putting these together, combating these rejections. And then these two subjects go together. There's a reason I'm spending time here. We have heard both from administrative law judges, so PTAB judges, the appeal judges, and more broadly from the patent community that judges are going to be overturning 101 rejections more often. They're being encouraged as a policy to scrutinize those rejections harder, to be more critical of examiners on Section 101 rejections. And we've actually seen this happen. There was an article in a patent specific law publication that identified about 12 judges who had 101 reversal rates that were in the single digits that in the past 6 months have jumped considerably to 60 and 70% reversals. So we're actually seeing, excuse me, we're seeing that in practice. The judges are being more aggressive and holding the examiners much, much more accountable here. And I think that's only going to continue with declarations being underscored. There's going to be more record evidence for the judges to overturn and reverse those rejections and send those cases back for allowance, most likely. So, two important areas to know. I'll mention for everybody's sake. So, those 101 rejections are important. We're seeing tons of them. I mentioned software. Obviously, AI is very big right now. Everybody's looking for those AI innovations. So this is directly related to the 101 area. That's certainly a significant area. The other side of the spectrum would be in life sciences. Not having anything to do with computer related inventions, but having to do with whether or not a naturally occurring substance is part of the claims and things of that nature. So I think it applies equally, even though a lot of the discussion has been over artificial intelligence and machine learning as it relates to Section 101. Take a quick pause. If there are any questions, I want to invite them during the discussion. I know it's sometimes difficult to come off mute and ask the question, but I encourage any of it. I'll move on here and we'll have a session at the end as well, but please feel free to interrupt and ask a question if needed.
So thank you, Stephen. So first, there's a few people requested if you could make the slides a little bigger, because it's for some it's hard to see. And then the question here is from Martin is, up to how many NFOAs will the PTO send out until FOAs?
Okay. So first, let me ask: are the slides front and center now?
Yes.
Okay, very good. Yes, so those non-final office actions. So really, in a given phase, typically you're going to see one non-final office action, one final office action. There are things that can happen that would force the examiner to issue more than one non-final office action. It's pretty rare, but there are instances. It's usually where an examiner's made a mistake, either legally or with the technicalities of the case. I would say maybe 1 in 50 or even 1 in 100 cases, you'll see a second non-final office action. But in terms of overall, if an applicant were to file an RCE, go through another phase, file another RCE, there's no limit on the number of phases that you're allowed to pursue. And so the number of non-final office actions in a given case could go on as long as the applicant wants to continue fighting the case. And sometimes we have clients and applicants who simply want to be very aggressive and they want the broadest scope of claim coverage, and they may undertake lots of RCEs to get to have that discourse and to pursue really aggressive patent protection. Thank you for the question.
Thank you. And if anybody has any other questions, please put them either in the chat or Q&A. Just remember that if you want to remain anonymous, only the Q&A can allow you to do that. So thank you.
Thanks, Ella. Okay, another area I think the seasoned practitioners want to perk their ears up for these. This is a little bit of the core post issuance things that I can help folks just think about. These might be aspects that you've heard about, but maybe you haven't thought about how it applies to prosecution itself and the future development of patent materials. So patent validity challenges. This is part of and a consideration of enforcement or what your patents can do in terms of granting you some exclusivity to certain technologies. But the counterpoint is if you were to ever go out and want to license or even enforce a patent, then the opportunity exists that another group who you might want to enforce them against will want to challenge the validity of the patent that you're issued. So challenge whether or not the patent should have been granted or is valid to be used in enforcement action. There are three, I'm going to call them three primary ways. There's another way through the other administrative bodies, ITC, but we're going to focus on these three today. Inter partes review, ex parte reexamination that I'm sure everybody's heard a lot about lately, and then also district court. Let me start with inter partes review, IPR. You've probably heard a lot about this in the past, 5 or 10 years. This is the process that I clerked for and is a primary trial process at the USPTO. This is a proceeding in which both sides are involved in the proceeding and there's briefing back and forth. But ultimately, a challenger is bringing to the office a challenge against a patent and says this patent should have been granted. It has to be limited to prior art publications, so written documents that show that the patent shouldn't have been granted, that predated it. And the patent owner comes and defends their case. There are opportunities for amendment, but we don't see them used successfully in practice. And ultimately, there's a hearing if the parties want it, and then the panel of judges decides whether or not the case should have been granted and whether the validity exists for those cases. Inter partes review, a lot of people will know, has been coming under a lot of scrutiny. It's been a powerful process, an alternative to district court litigation, where parties can bring, to an expert panel the ideas of the idea of whether the patent should have been granted and the technical issues that are underlying that decision making. But it's come under a lot of scrutiny because essentially the policy and the political issues behind the process have been scrutinized more. And ultimately, the USPTO has decided to constrain this process and to use things like discretionary denial to take on far fewer cases than it was taking in the past. And this is really, really new. I mean, within the last 12 months, within the last 6 months, we've seen a huge downtrend in the amount of IPRs that are being taken on by the office. And also the filings are down considerably because folks know that this process is not being used as frequently. It's not being accepted as frequently as it was in the past. The counterpoint is ex parte reexamination that I'm sure folks have heard is on a huge uptick. This is a similar but parallel process to inter partes review, where a challenger comes in, demonstrates a challenge to a patent in a similar way that inter partes review would have it, but then the challenger is not really involved in the proceeding any longer. The patent owner can go in and defend its case if that case gets taken up, but the challenger does not. It's not no longer involved. So hence ex parte, meaning excluding the party, versus inter partes review involving the party. So some differences there I'll get to in just a second, but ex parte reexam up but big time. This is a process that's existed for a long time, but the number of filings, the number of acceptances of those reexams are up considerably, and it really is the new very acceptable way to go into the patent office and challenge an existing patent. So we want to be aware of this as we're constructing our patents, as we're prosecuting them. Where could they be acceptable, susceptible rather, to these processes? And then the third being district court. Of course, if you're in a patent infringement lawsuit, then a challenge to the validity can be taken up by that court as well. So the first thing, and one that I think is easy for practitioners to not put to practice for them, is the different standards that are applied in these different processes. Okay, and I have just the two differences. The claim construction standard is the first, and then the evidentiary standard is the second. So starting with inter partes review, we have plain and ordinary meaning. The plain and ordinary meaning is the claim construction standard in inter partes review. That was a change from a few years ago. The office originally had a different claim construction standard, and they tightened it to a slightly narrower standard. And if you look down at district court, it's the same P&O, plain and ordinary meaning. So that claim construction standard is important to understand when you're going in as either a requester challenging a patent or as the patent owner when you're developing your patents, because you want to know how are my claim terms going to be interpreted under those challenges. Um, and then come back to the inter partes review, the preponderance of evidence standard. So the amount of evidence when we get to the end of the day and we weigh the evidence that's available for the patent in favor of the patent staying valid and against the patent in favor of invalidity. The preponderance of evidence standard is the standard used by the office in both proceedings, as opposed to district court, the clear and convincing evidence standard, which is understood. It's a legal standard, so we don't assign numbers to it, but it is clear and convincing being a slightly higher standard that has to be proven to invalidate a patent. So let's back up to the claim construction standard. In inter partes review, plain and ordinary. In ex parte re-exam, we see the broadest reasonable interpretation. That BRI standard is the standard during normal examination. And as most folks know, it means whatever is reasonably encompassed by the language of the claim. So it can be stretched pretty far. It has to be just reasonably within the claims, as opposed to the plain and ordinary meaning, which is more akin to saying, what do we really think the words mean, rather than what's the broadest, realistic reading of those claims. So if you can't tell from my description, the BRI is a broader reading and more art is going to be available to be applied to the claims, typically under that broadest reasonable interpretation standard. Okay, why do we care? Well, because in re-examination, broader interpretation of the claims is going to mean more art could potentially apply. We're going to have a little bit more latitude to reason how the art applies to the claims. Then when we get to a plain and ordinary meeting where the content of the application, the specification, maybe dictionary definitions, what an expert has to say about the interpretation, they're probably going to have significant bearing. And there's going to be more opportunity for the patent owner to say, no, my term is a little bit more narrow than that, and so it avoids the art, and my patent remains valid. Whereas at re-exam, they don't have quite as narrow an interpretation standard, and so it's a little bit easier to get a challenge to invalidate a patent there in terms of just the claim construction standard. And then you see also preponderance of evidence at re-exam as well. For talking purposes, 51%. If 51% of the evidence says that the case is the patent is invalid, then that's all you need, 51%, compared to district court where you might need, let's say, 75% of the evidence to support your case. And in fact, I recently put out a little writing on a case that was GoDaddy, where there was a dichotomy. At inter partes review, the panel determined a case was invalid, whereas at district court was proceeding in parallel, the jury determined that the patent was valid, and we had two differing conclusions by those cases. The interesting part of this case is Director Squires sent the panel back, or at least sent a review panel to look at the decision and to decide whether they need to send it to the judges to have more explanation about the difference in the jury verdict and their decision. But one explanation that could come out of this is, well, the evidence standards are different. So for talking purposes, let's say they both agreed equally that 60% of the evidence supported that the patent should have been invalidated. Well, 60% is good enough at inter partes review because the preponderance of evidence standard is lower. Whereas in district court, the 60% wouldn't rise to their 75% standard. Again, these numbers are fictitious. They're just for speaking purposes. But the point being that the standard of evidence explains why you could have a different result in two different jurisdictional bodies. And so understanding both the evidentiary standard that applies and the claim construction standard helps you to understand and interpret where the challenges to your patent could be lying for your competitors to come in, challenge those patents, and ultimately cause a problem for your protection. So what we do is we use knowledge of this process to back into our patent applications, our amendments to the claims, the prosecution process that we undertake, so that we're always thinking about how those patents can be strengthened and you can build a portfolio of stronger processes. I spent quite a bit of time there. I covered a lot. I mean, we could have an entire course on just these processes and probably each individual one. Um, I'll pause for any questions there. And while people are thinking if they want to ask questions, I'll mention the other correction, reissue processes at USPTO. Little less going on there, but I'll just mention them as options. Al, it sounds like you have something for me.
I don't have, there are no more questions submitted. So at this point, if anybody also would like to raise your digital hand, there's a button at the bottom. You'll see raise hand. I can unmute your mic if it's easier for you to ask that question that way. Or you can put your questions in chat or Q&A, whatever is easier. But while people are thinking of questions, I'd like to thank you very much. This has been indeed very informative and very detailed presentation. I think it's a lot for people to think about. So,
Great.
like,
Yeah, I mean, do we have a few more minutes? I'll just flick through. I mentioned settled expectations, all the things that we're thinking about in terms of whether or not inter partes review could be undertaken or not. Definitely a difficult one, and we have a petition for certiorari up to the Supreme Court to decide whether those constrictions on inter partes review are allowed to take place. So we'll see some decisions there. I think we mentioned a bit of this. Oh, I will take a moment to mention is that with the uptick of ex parte reexamination, many more cases being filed for reexamination rather than inter partes review. Director Squires has just recently issued a new pre-order procedure. So formerly, it was very rare that the patent owner um, would enter a response before the actual reexam was accepted by the office. And the reason they wouldn't do that is because if they did it early, then the challenger got a chance to speak again. Whereas if they waited until the office accepted the case, then the challenger could no longer be involved and couldn't respond to the issues that the patent owner would point out and say, no, our case should remain valid. Now the new pre-order procedure allows the patent owner to come in and make an early response, and there's only very limited opportunity for the requester, the challenger, to actually make any reply. So this kind of shifts. It's a recognition by the office that re-exams are the way forward right now. And they're saying, okay, we see a little bit of an imbalance. We want the patent owner to be able to point out if there's something glaring that shouldn't make this case go forward, then they should be able to speak on that. So that's new process and definitely an indication that the office is recognizing that re-exam is the new tool that's going to be used more frequently. So I summarized a little bit application lifecycle considerations, the patent lifecycle considerations, portfolio considerations. I mean, ultimately, my goal is to match the intellectual property protection to whatever the commercial business needs are. And the reality is that we don't know what those commercial business needs are at any given moment. We only have the information in front of us that the applicant and the clients know. And as they learn more information about their marketplace, we need to be able to adapt the IP to be able to do that. And that's sometimes difficult to forecast. So we want to use really good practice, informed decision making, like knowledge of these later processes, in order to provide some latitude so that years down the line, the business, as it pivots and understands more about its clients, they can now redirect the IP and still use it as useful and not find themselves in a boxed in position in terms of a mismatch between what they filed and what they actually get out of the intellectual property. So that's ultimately what we're driving here, and that's the goal of all this information is to try to create that match. So I'm gonna stop there. I really appreciate the opportunity to speak, but I really welcome questions. Again, please either write them into the chat or take yourself off mute. I'd love to hear some discourse, any reflections from those that know about all these changes and how they're using them in their practice.
Yeah, thank you. Yeah, anybody who wants to speak, please raise your hand. I can unmute your mic now, or anything that Stephen didn't cover, you'd like him, any controversial questions, all welcome. Or if you think of questions later, but that you didn't have a chance to ask now, there's Stephen's contact information, or you can email me and I will forward your comments or questions.
Yeah. Ala, thank you so much. It's been fun to go through this process and think through, like I said, some of the stuff I've mentioned has happened only in the last, 20 days or so. It's exciting to see all the new changes going on and see that it's actually affecting patent process and the different tools that we have at our disposal. So really happy to share with you. I welcome anybody to reach out afterwards. I realize it's not always so comfortable to reach out in a forum and ask a question we don't know the answer to, but please send them to Ala or to myself, and happy to talk through it or just discuss issues with anyone.
Yeah, thank you. Well, thank you so much. Thank you to everybody who attended, and especially to everybody who stayed until the very end. Hope you found this helpful. If you have any suggestions for future sessions, please send them my way. I will try to find a speaker for a future session. Leave a comment on our Startup PMD YouTube channel if you're watching us on YouTube. And again, thank you so much, Stephen. This is a lot. I know you're busy, so thank you so much for taking time out of your busy professional life and spending time with us. So we have one question here. You have a minute. So patent is new to me. What should I start with to determine if my new idea of AI platform is worthy to file a patent or not?
Great question. We have a new AI discovery or invention of some sort. Well, starting from the beginning would be to kind of try to outline the idea. You don't have to try to write a patent application, but try to outline the idea, figures, descriptions of how it is and how you think it is different. I mean, really, if you have no experience in talking with a patent professional, would be the right course to discuss what it is. Most of the time, when I have folks that really don't know the field and they don't know what the commercial industry looks like there or whether it's protectable, we're going to try to challenge that a little bit and say, well, what was known before and why is this different than what is out there? How does it do it differently? How does it accomplish something differently? There's some other things you can do is you can conduct a patent search, a prior art search to see has the idea been out there published and maybe it was just hiding and even if folks aren't practicing it, if it's been out there in publications, then it could be an obstacle to overcome. And that's another data point you can look at to decide if patenting is a something you want to take on. But it is a forward-looking game. You have to decide to go file that application in order to, first of all, see the real art that's out there that might be in the way. And then, ultimately, it's a backward-looking decision to decide whether you carry that process on and take patents on. Before you go out, you certainly want to be doing all this before you go out and publicly announce what your idea is, because that can start some clocks that can interfere with your patent protection. So definitely advise finding a patent professional, getting some input there. But searching can be a good way to start with it. Also, the provisional application process that can avoid some of the government fees and still buy you some time to go through that decision-making process. Thanks very much for that question.
Yeah, thank you. And I also would like to add, for those of you who are University of Maryland researchers, the first stop should be the Tech Transfer Office at UM Ventures. So submitting that submit an invention disclosure form will put you in touch with an innovation manager who is knowledgeable in IP. Innovation managers do not file patent applications, but they do make assessments and decisions, and then they work with professionals to actually do the actual filings. But Ventures should really be your first stop if you are a University of Maryland researcher. So yeah.
Yes.
So thank you. I don't see any other questions, and it looks like we are at time. So this is perfect. Thank you for that last questions. And again, thank you so much, Stephen, for preparing such a fantastic and very detailed presentation.
Thank you so much, Ella.
Yeah. Thank you.
All right. Thanks again.
Bye.
Go Terps.
Hey.